but I'm Mr. Batra and not Mr. Bhatt. So I think
I'm so sorry, sir.
that's all
I'm
right.
so sorry.
That's fine.
Our another eminent speaker today is Mrs. Lalit Mohini Bhatt, an advocate and mediator with 29 years standing. Mrs. Bhatt is a senior founding partner of the firm Law Links. Mrs. Bhatt has also been nominated as an arbitrator by the High Court of Delhi in a number of arbitration disputes, where she has heard and decided various disputes and rendered final awards. She is a trained mediator since 2006 and is enrolled with Samadhan ever since then. Ma'am has conducted mediation sessions in over 300 cases and is also enrolled as a senior mediator with the Bombay Chambers of Commerce and Industry. Her forte in mediation law is commercial, labor, and family related disputes. She has underwent the advanced mediation course and has also underwent the Train the Trainer mediation program at Utah University, USA. She has been accredited as a mediator by the Chartered Institute of Arbitration, London, and is also an advisory member of the Arbitration and Dispute Resolution Cell, PhD Chambers of Commerce and Industry. Ma'am is also a lifetime member of FICCI Ladies Organization. Ma'am, it is actually an honor and a pleasure to have you here.
Thank you. Thank you for inviting us.
Thank you.
Thank you.
So now we'll proceed with the webinar, ma'am and sir. So what we can do is, Rubina, I think you are asking the questions to ma'am, right? So I think question one, you go ahead, please, and take it. Rubina?
Yes.
Yes, please. Thank you.
So ma'am, just to start the webinar, our first question is, which is a general question. What is ADR and what are the alternate kinds of dispute resolution mechanisms which are prevalent in India?
Good evening, everybody, and thank you, Rubina, for your questions. It's twofold questions, so without further delay, I would just go straight to the ADR. So, a broad definition of ADR is it is a procedure for settling disputes without going into litigation. So it is a collaborative process and it allows the parties to understand each other's positions, unlike in litigation. So technically, typically we have a lot of disputes are resolved through litigations, where parties approach the appropriate court of law to seek redressal of their grievances. Litigation is a time-consuming process and parties have no role in the outcome of the litigation. So in most of my mediations, when I start and I tell the parties, well, this is the process, which is your process, and you are the people who are going to decide what is going to be the resolution for your dispute. Who else is better than deciding? You. Who knows better than you about your dispute than anybody else? So litigation does not give answers to the parties in a manner where they want, in what manner they want to decide the disputes. So it's a third party who basically decides the disputes. So the process of litigation can be quite expensive and also long drawn. Given the enormous load of cases that we have in the court, there's a lot of pendency. So in that context, I feel that ADR presents parties with efficient, cost-effective mechanism for dispute resolution. And as far as the second part of your question is concerned, that what kind of alternative dispute resolution mechanism that are prevalent in India, in my opinion, there are primarily 5 kinds of ADR mechanism that are prevalent. One is arbitration, mediation, conciliation, lok adalat, and negotiations. So as far as arbitration is concerned, arbitration is a process. It is again under the Arbitration and Conciliation Act 1996. It is a process of dispute resolution where parties based on an existing agreement decide to mutually appoint a third party arbitrator in accordance with the terms of the agreement. Parties here have directions they have discretion in their choice of arbitrator as well as the seat of arbitration that they want to choose, and under the law which the dispute is to be decided by the arbitrator. So that is as far as the arbitration is concerned, as a broad definition of arbitration. And conciliation is also a part of Arbitration and Conciliation Act. It comes under the Part 3 of Arbitration and Conciliation Act. Conciliation involves a third party who plays an advisory role in enabling parties to mutually reach a resolution of the dispute. So both these forms of dispute resolution are governed under the Arbitration and Conciliation Act of India 1996. And of course, negotiation, everybody knows, is simply a process whereby parties to a dispute themselves try to strategize and bring a resolution with an aim to reach the best compromise, so that a settlement of the dispute can be arrived at. So it is an intrinsic part of arbitration and conciliation. And whereas mediation, in the broad definition, there are 3 points which are very important in mediation. One is that voluntariness, neutrality, and confidentiality. So in my opinion, the mediation is a voluntary method of dispute resolution where a neutral third party called the mediator facilitates a settlement between the parties. It is a confidential and structured process where the mediator uses his or her special communication, negotiation, and social skills to assess the parties in arriving at a mutually acceptable solution themselves, basically. So unlike arbitration, mediation is not adversarial process at all. The mediators act as a facilitator, as an advisor, not as an advisor, as a guide, as a facilitator for the parties to reach a settlement on their own terms. And the third and the last one is the Lok Adalat. Lok Adalat has been here since '87. It's governed by Legal Services Authorities Act 1987. So Lok Adalat is another dispute redressal mechanism. It is a forum. It is a forum where disputes or cases pending in the court of law or at a pre-litigation stage are settled or resolved amicably. So Lok Adalat have been given the statutory status under the Legal Services Authorities Act 1987. So under that act, the award or the decision made by the Lok Adalat is deemed to be a decree under the Civil Code, and it is final and binding on all the parties. So these are primarily the different kind of ideas which are present in our country as of now. This is in my opinion. So this is the answer. I think
that's the question done. Thank you, ma'am. And now, Sudhanshu sir, over to you for this one. Are settlements arrived at through the ADR forums binding on the parties? And if so, how are they enforceable? Thank you, sir. Please.
Yeah, thank you, Rubina and Udit, for having organized this. And the whole idea is to familiarize the stakeholders more than the legal fraternity that, as I've already said, is flooded with this kind of information. And sometimes they feel that it's too repetitive. So the idea was to rope in as many participants from outside the legal field. And I think Mohini has already discussed what are the various forms of ADR. Apart from the fact that arbitration, mediation, conciliation, negotiation, and Lok Adalat, there is also judicial settlement, which is also a form of ADR. Now, ADR by its very name is Alternate Dispute Redressal Forum, which means that it is a forum where disputes are settled outside the traditional adjudicatory system known to all worldwide. It is alternative, but that doesn't mean that it is a substitute for a traditional legal adjudicatory system. It is in fact complementary to the traditional legal system. There are certain issues which only the courts can resolve, which only the adjudicatory mechanism can resolve. But apart from those, there are several issues that are in conflict between the parties, and those are best resolved through this ADR which I prefer to call as the appropriate dispute resolution rather than the alternative dispute resolution mechanism. The question that comes to one's mind, and you asked me this question, is, are these binding? Are they enforceable? Yes. In fact, ADRs form part of the judicial system. It forms part of the judicial system because it finds place in section 89 of the Code of Civil Procedure. If you look at the section gives all these alternative dispute resolution systems where parties can be referred to by the court in pending cases. So I'll first come to mediation. How is a mediation settlement arrived at between the parties? Yes, it is. It is binding and it is enforceable. Now the question is, how is it binding? Mediation, as normally accepted and practiced, is when a list is pending before a court and the court finds that there are elements of settlement between the parties. The best thing that parties should actually do is to go and sit with somebody who's a neutral third party, and that neutral third party helps them to arrive or assists them to arrive at a settlement. So mediation commences when, in a pending litigation, the parties are referred to for mediation. Now they are referred to either an institution or to a person nominated as a mediator. All the courts, the usual practice is to refer it to the court annexed mediation center. Every high court has an annexed mediation center. The subordinate courts have an annexed mediation center. The Supreme Court has an annexed mediation center. There are tribunals now that have annexed mediation centers. So the matter is pending before the court, and the court refers the parties for settlement to the mediation center. The mediator is appointed by the center. The parties consent to the appointment of the mediator, and the settlement sessions begin. The mediation sessions begin. Now, mediation sessions are those kind of sessions that the mediator helps the parties to focus on their present and the future interest while maintaining complete confidentiality. He's supposed to be unbiased and a neutral person. And suppose when a settlement is arrived at, now once the settlement is arrived at, it is drawn up into writing. As far as possible in the language of the parties should understand what they are writing, what kind of settlement they are arriving at. And once that is written and accepted, all the terms, they are signed by the parties. Then the mediator signs that settlement. Now, once the mediator signs that settlement, he forwards that settlement to the court that referred the parties to the center for mediation. Now, during this process, the matter in the court is virtually comes to a standstill. It doesn't move because the parties are making an effort to find a solution. So when the settlement goes to court, the court examines the settlement on the principles of Order 23, Rule 3, which is a provision that deals with compromises between the parties. So the court needs to see that the settlement is tenable in law, it is not against public policy, it is enforceable, it is fair to the parties, which is also a role of the mediator, because the mediator, you see, the mediator is not a person who's going to judge and decide which party is right or which party is wrong. So the mediator is acting as a facilitator. So the mediator needs to ensure that the settlement that the parties arrived is fair, just, tenable, and also has addressed the broken relationships that have brought the parties to court. So it either restores those broken relationships or at least stops those relationships from being further deteriorated. So the court examines that settlement and passes an order in terms of the settlement. Now, that order is akin to a consent order or a consent decree, depending on what is the nature of the case. Now, once that is passed, then it becomes a decree or an order which is enforceable under the Code of Civil Procedure. Now you see the mediation settlement becomes binding only after the court passes an order in terms of the settlement, accepts the settlement, binds the parties to the terms thereof, and it is then enforceable as a decree or an order. Now, that is a process of binding the parties. Now, till the time the court passes an order, the mediation settlement itself is not enforceable. So what is important is that the court should pass an order accepting the settlement on the same principles as that of Order 23, Rule 3 CPC. Now, conciliation, which is another form of ADR, is also enforceable if a settlement is arrived at conciliation. Now, there is a slight difference between mediation and conciliation. Mediation, as I said, is a matter where the parties are referred by the court in a pending case. In conciliation, if one party or both parties decide that instead of going to court, let's find a person like Udit, who is going to be assisting the parties to settle the dispute. So they go to him, they find he's a neutral person, he's trustworthy, he has the knowledge of law, he's well qualified, he's well experienced. So we have complete trust in him, and he goes to him and he facilitates the parties in arriving at a solution. Now, the mediator's role is slightly different. I won't go into it because then we'll go into another tangent altogether. I'll confine myself to the question. So let us assume a conciliation has happened and a settlement has arrived at between the parties. Now, is it binding? And is it enforceable is the question that Udit has posed to me. Yes, it is. How is it binding? It is binding because the settlement itself, the conciliated settlement, now, this is not a mediation settlement. The conciliation settlement is, in fact, has the same status as that of an award. So it has the same status and effect of an award under Section 74 of the Arbitration and Conciliation Act 1996. So you see why I say that ADR forms part of the judicial processes. It finds place in Section 89, all these kinds of ADRs. Now, conciliation forms part of Part 3 of the Arbitration and Conciliation Act that makes the settlement akin to an award. It is not an award. It remains an agreement, but it has the same status and effect of an award. Thereby, that settlement itself can be enforced as an award under Section 36 of the Arbitration and Conciliation Act. So you see, this kind of a settlement also has legal sanctity, it has legal force, and it is enforceable. Now, these are the two kinds of binding nature of ADRs and the enforceability. The third is judicial settlements, where with the assistance of the learned judge, the parties arrived at, the order is passed, and that's a consent order. Lok Adalat has a slightly different method of enforceability. That too is binding and it is enforceable. That is governed under the provisions of the Legal Services Authorities Act, as Mohini just pointed out. Now, prior to 2005, when Section 89 was also being introduced, I think, prior to 1996, the Arbitration Conciliation Act, there was an amendment in the Legal Services Authority Act where another chapter was introduced, which was conciliation. Now, that conciliation is slightly different from the conciliation that is provided under the Arbitration and Conciliation Act. So, Lok Adalat, there are two kinds of Lok Adalat under the Legal Services Authorities Act. One is the Lok Adalat organized by the authority for the purpose for which it is set up. For instance, motor accident claims, the traffic challans, the electricity disputes, and so on. Those are really, I won't use, the statute doesn't use the word temporary, but they are those Lok Adalats organized for a particular purpose. Now, there, when a settlement, then the Lok Adalat the members of the Lok Adalat persuade the parties to settle. Now here they don't go into the interests of the parties, the present and the future. They talk about what is best for you. This is the legal position. You should settle on this. It's like a bargaining process that goes on between the parties. And whatever, suppose a settlement is arrived at, that is like a civil decree under the Legal Services Authorities Act. So that's also a civil decree and is executable like a decree. Now, the permanent Lok Adalat, which is different from the other Lok Adalat, is a Lok Adalat which has limited pecuniary jurisdiction. And those kinds of Lok Adalat, where a settlement happens between the parties, excellent. That again becomes a civil court decree under the Legal Services Authorities Act. But in case a settlement does not happen, the Lok Adalat has the authority to decide for the parties. Now you see, that's the distinction. In mediation and conciliation, neither the mediator decides nor the conciliator decides. But in permanent Lok Adalat, the Lok Adalat also decides for the parties in case the parties don't arrive at the settlement. And that is the case of permanent Lok Adalat only. And that's the new introduction that was made in the Legal Services Authorities Act. So both these things in any case are binding on the parties, are executable as decrees of the court. Then the other is, of course, I think we've covered all the ADRs.
Yes.
Lok Adalat, and that's how that answers the question whether they are binding and enforceable. So you see, any ADR, any alternate dispute resolution process that is prevalent and practiced in India has a binding nature and is enforceable, and therefore we say it is part of the judicial system. Therefore it is complementary to it and not a substitute to the traditional adjudicatory system. Yes, Udit. Yes.
Yes, sir. Thank you, sir. I think now it is to Mohini ma'am, which is on ODR. Yes, Rubina, please.
Yeah, ma'am. So now we request you to actually tell our viewers what exactly ODR is.
So firstly, ODR, that is online dispute resolution. So that is ODR is the abbreviated form. So that's how it is defined, online dispute resolution. So ODR is basically a process to resolve dispute outside the courts using technology to facilitate the resolution of disputes between the parties. So it primarily has arbitration, negotiations, mediations. It's combination of all basically, and it carries out, but only difference is that it is carried out on a technological platform or with the help of technology tools. So in brief, ODR involves 4 parties. 2 parties to the dispute, the claimant, the respondent, the mediator or a conciliator or an arbitrator, and the third is technology. So the technology is the one which is the 4th one, whose help is needed for resolving disputes through this platform. So actually ODR has been in use for quite some time, and several entities have basically devised a creative ways to resolve their disputes. So, and with the huge expending huge resources on each of the disputes basically. So it uses primarily a lot of artificial intelligence and some large cooperation to analyze different kinds of disputes that arise in the course of the business. So, and there is no since the artificial intelligence is used, so there are straitjacket formula for compensations to be paid out to the parties who are involved in a dispute. So this has immensely helped reduce the volume of litigation that these corporations are faced with. And it is quite quick and efficient means of dispute resolution for issues arising out of customers' complaints, product deficiencies, etc., etc. So where the large volume of disputes are there, so technology is used, ADR, artificial intelligence is used for resolving these kind of disputes. So especially in these pandemic times where it is a practical necessity to avoid in-person meetings and gathering, ODR has a significant role to play. in making dispute resolution accessible and efficient. So in my opinion, in this context, the term ODR can also mean the various forms of ADR carried out through an online platform. This would enable parties and arbitrators and mediators in different locations to use technology to carry on dispute resolution process without having to travel or to meet personally. So this platform helps parties to a dispute reach out to each other through this technological platform with a mediator or an arbitrator or a conciliator and resolve their disputes. So here the fourth party, which is a technology which comes in aid of the parties to a dispute. So that's what, in short, the meaning of ODR. So I guess any other thing that you would like to ask about this? Basically, maybe we move to the next question, keeping the time constraints also and the number of questions that we have.
Yes. Thank you, ma'am. We'll take this now on the structure. So basically, now the online dispute resolution and the traditional method that we had, where the parties used to physically meet and sit and discuss. So I want to know, sir, whether the structure in the what structure does the conciliator or a mediator follow in this ODR process, as compared to the mediation and conciliation done earlier, the regular one?
Yeah, Udit, to answer this question, I think first we need to very briefly talk about what is the structure of mediation. First, we must understand what is the structure in mediation and what is the structure in conciliation. In the legal adjudicatory system, we have a party going to court by filing a plaint or a suit. The other party is summoned, they file the written statement. The plaintiff comes and files replication. Documents are filed, admission and denial happens. Issues are framed by the court. Then the parties are put to trial. After the trial is over, they prove their various documents and so on, and the arguments are heard. And once arguments are heard by the court, the judgment is pronounced based on whatever material is available before the court and by applying the law to the facts of the case. Now that's one structure. Now, does mediation and conciliation also have any structure? I would say yes. The structure is not as rigid as I just pointed out, which is under the CPC. It is a structure whereby when parties come to the mediation center or to the conciliator first develops a rapport with them, familiarizes them with the process of mediation, tells them that, listen, this is not a forum where I am sitting here as a judge. It's a voluntary process. Parties have volunteered to come. So obviously they're looking for a solution. Now, when they're looking for a solution, they're looking for a solution which is obviously not the position or the stand taken by them in court. They're looking for a solution that satisfies both the parties, because our objective is that the parties should walk out of the mediation center or the conciliation center in a win-win situation. One party loses and one party wins in an adjudicatory system. But in a mediation, so our whole endeavor is, is that the parties must be happy with the settlement, must understand the settlement and go away in a win-win situation. So the structure is that you talk to the parties jointly, then you talk to the parties separately, maintaining confidentiality inter se between the mediator and the parties, between the parties, and between the court and us and the mediator. Now, this structure is not codified anywhere. So it is flexible. Unlike the adjudicatory system, which has a rigid structure, this structure is not codified, so there is flexibility. You could first start with a separate session and then end up with a joint session. Or best thing to do is to start with a joint session if the parties maintain the decorum, if the parties have the capacity to listen to the other side, listen to the point of view of the other party. Or if you feel that the separate sessions will be many more than the joint sessions. So all this process, although it's structured, because the whole idea of first sitting with the parties jointly is to gather information. Once you gather the information, by listening to the parties, and that's where communication skills become very important. Why we train mediators is because we want to hone their skills for communication, for negotiation, for dealing with the parties, for understanding their interests, and so on. So there is a structure that the mediator or conciliator is following so that parties ultimately narrow down their differences, take out those issues which they are in agreement with, separate those in which they are not in agreement with, try and help them to come out of those disagreement issues by looking at their interests for now and for the future. Now, then that is really the structure. Once the settlement is arrived at, it is drawn up, it is in writing, the parties must sign it in the presence of the conciliator, the mediator, and all that. But the point is, there is a certain amount of system, certain amount of step that needs to be taken. Those steps can be changed depending on the circumstances of the case, depending on the emotions of the party, on the socio-economic background. What are the reasons why? There are so many things. When the parties come up with, they are sort of full of emotions. They are full of grievances against the other party, and there are certain blocks created by them. So we must follow that structure to help them come out of that. Now, in ODR, which is actually not another ADR, but it is part of ADR, just that it is in a different format. And the format is electronic media. And therefore, the structure basically remains the same. But one issue, for instance, I'll tell you out of my personal experience. I am doing some online ODRs, online mediations. Now, they're akin to ODR. And where electronic platforms sometimes acts as a barrier to help the parties on their emotional front, on their interest fronts, because it comes as a barrier. But therefore, my personal view is that there are certain matters which are most suitable for ODR, but there are certain matters which may not be that suitable. But at the same time, it's not that they are not effective. They are effective. But you need to also overcome those barriers as you go by. You can have separate sessions with the parties, even through ODRs, through this system. So the structure basically broadly remains the same, except that I think the skills that the mediator or the conciliator need to use while dealing with the parties, while talking to the parties, has to differ a bit, depending on the facts of the case, the circumstances of the parties, and so on. So looking at the structure, yes, it is the same. But question is, once an agreement is signed, of course, I think you'll probably go on to how are those enforceable settlements in ODR, which we'll come to later. But by and large, the structure in conciliation mediation in physical sessions and in ODR is the same.
Ma'am,
thank you, sir. Yes.
As Mr. Batra rightly said, like sir pointed out, that there are certain disputes which can be resolved by ODR and certain disputes which cannot be resolved by an ODR. So here, ma'am, we would request you to guide us as to what are the disputes which can actually be taken up by online dispute resolution platform and can be resolved, most suitable for ODR.
Yeah, this question, yes, and especially in these times when everybody is put into this situation where we had never anticipated that we will be, and suddenly the ODR has become the new normal. Everything is now it used to be one of the things where probably people would be doing it in earlier times, very few cases which would be referred to ODR, but now something which has become a new normal, which has become a necessity. So as I mentioned before, in these pandemic times, ODR has a great significance. We all know that courts are also not functioning to full capacities. Commercial and other disputes are on the rise. And of course, these disputes have to be resolved sooner than later. So in order to get affected parties, to get them timely and effective remedies and resolutions of the dispute. So, in my opinion, ODR, as we are on this topic, digitization and the use of technology in various creative forms has caught on. And as we know that in this short span of few months, courts are hearing matters through video conferencing. Everybody is gearing up to file matters through e-filing, and matters are listed. So everybody is devising new ways to reach out, and it's all being used on a platform, which is a technologically based platform. So arbitrations are being carried out through video conferencing. E-filing of documents is catching on. Youngsters, as you know, these days are also extremely comfortable with the use of technology as we were, as compared to us, probably. Now we are also gearing up and catching up to this and prefer this over cumbersome, youngsters especially prefer this form of filing and form of this platform. So instead of this cumbersome paper filing or in-person meetings. So with faster solutions being more accessible, the long drawn process of litigation is not preferred. So ODR presents an ideal situation for solutions in these issues and has several advantages that are especially relevant in these times. So with the advent of technology in dispute resolution, we can see that the matters which are used, which can be probably are used basically, which can be dealt with, as you had asked that questions. So, so the two, which in my opinion, which can be easily resolved through this ODR platform, are the matters with regard to this arbitration. Of course, there are commercial IPR disputes. There are certain B2B disputes, which is called disputes between business to business, business to customers, or consumers disputes, or the cases of resale of used of goods, and the e-commerce platforms, etc. Like now, you know that Amazon, Flipkart, and all these big B2B companies have large number of disputes which can be resolved through one straight-jacketed artificial intelligence enabled platform. So they will have a structural one-line answers to all the disputes. So basically, these are the kinds of disputes that can be resolved. And some of the disputes, in my opinion, which can be probably resolved are property rights, infringement of copyrights, trademark violations, commercial disputes, disputes arising in the course of business for small and medium enterprises like MSMEs, etc. are the disputes that can be resolved through these platforms. And there are certain disputes like compoundable offenses also, which involve possible settlement between the parties as to the monetary compensation and not adjudication by the courts on merits. So where parties are willing to drop charges on reaching a settlement. So these disputes also can be resolved through a platform of ODR. So in my opinion, so these are some of the disputes which can be resolved through this platform.
Thank you, ma'am.
That...
Yes, ma'am. In this, I would like to just ask you a small thing so that our participants know it. We as lawyers obviously know it. Is that can tax disputes or any dispute with the government be taken up in this ODR, in the ADR method or not? Can it be settled? The taxation dispute.
So now, as far as tax disputes are concerned, they have recently come out with a notification where they have this brought in a platform where these disputes can be resolved. I'm not aware, recently this has come into force, where many of the disputes as far as taxation matters are concerned can be resolved, where the parties can approach that nodal officer. So they have probably now have appointed one nodal officer who can actually resolve these disputes. But whether it is an ODR platform, that I'm not sure with. But yes, these disputes can be resolved through ODR platform. But as far as government and PSUs are concerned, right now, I think of course, they have a number of disputes, they have larger disputes, but for the government to come onto the mediation table is little difficult. There is a little problem in that, probably because I think it requires a little shift in the mindset in that sense from the point of view of public sector companies or the government. So coming on to the mediation or to an ODR platform is one and the same thing for them, but that requires a larger shift in the mindset of what they have. So yes, that is what. But of course, there are a number of disputes. Government is the largest litigant in before the court. So I think that is, once it gets through, I guess that is the major backlog of the cases will definitely will be.
Yes. So to add that, ma'am, I would like to say that, you and Sudhanshu sir and we and Rubina are ready to assist you all. We can make a representation and a proposal to the government how this can be taken forward. So that can help.
Definitely. ODR is one of the, I think,
Yes.
platform
So
which is
we can do that.
can be used.
Yes.
Sudhanshu,
Yes. Now I'll take it
would
up to
like to add
Sudhanshu.
something on this.
Yes.
Before you come to the next question with this, I just
Yes,
like
sir.
to add, basically commercial disputes can be more appropriately addressed through the ODR platform, where emotions are not of that nature as in personal disputes. Now, I'm not saying that personal disputes cannot be resolved through ODR. They can be resolved. It depends. For instance, there is a dispute between a husband and a wife. Okay. Now, I'm sure that physical presence of the mediator or the conciliator with the parties has a tremendous effect on helping the parties in resolving their conflicts, their underlying differences. And this platform may not be very appropriate, but in certain cases where both the spouses are very objective, it's not that you can have a blanket no to all those. Those are also possible, but largely commercial disputes certainly can be resolved through this platform. As far as the government is concerned, taxation matters, I also want to add, it's not only the mindset, which is absolutely right when he says that it's a mindset. Also, you see the policy of the government, the insecurity of the officers of the government of facing audits and vigilance inquiries for settlement comes in a huge manner in between, even if they want to do something, but there is a sense of fear, there is insecurity, because there is the concept in the government. Vigilance inquiry can start with a drop of a hat. If there is something which is, how can, for instance, 500 crores is due as taxation and settlement of, let's say, 300 crores or 350 crore happens. Now, the question will be why that person should give up 150 crores. I'm just giving an example. So it's not only the mindset, it is also the government's will, government's determination to take up this forum for settlement. Is it beneficial for the government? Today, 90% of the cases are by or against the government. Large number of cases are by or against the government. Unless the government changes its policies, it gives that kind of confidence to the employees that they will not be touched if whatever decision they take for a settlement is in the interest of the department or is in the interest of the government. I just wanted to add this. Sorry, I just thought it was necessary to.
Yes, sir, it was. Thank you, sir. And thank you, Mohini ma'am, for that. So, sir, in your previous question, you answered a very, very important aspect of confidentiality.
Yes.
You mentioned in mediation, when the mediator sits, there is confidentiality maintained if the parties privately discuss something. Right, sir? Now, sir, in the online platform, is it possible to maintain that confidentiality, and how can it be maintained is one part, sir. And I would like to add something more to it. Can parties also have a private session through this ODR process? Is that also possible? So these two can be covered, because if the second part can be covered, then the first part can definitely be covered under that, sir.
Yeah, Udit, I think it's a very, very interesting and a good question on confidentiality, because a core and a most crucial aspect of mediation and conciliation is to maintain trust between the parties and to maintain confidentiality, inter se between the parties and between the mediators. Now, the rules of the center respect that confidentiality. When the parties are physically present, the mediator or the conciliator ensures that no recording takes place, no information, no document is given to the other side so that it is misused or confidentiality is breached. But here, we do not know whether the recording will happen or not. We do not know whether the person is going to record or not because he's sitting in a different place on an electronic platform. Today, devices can help you record your entire session. But the point is, in law, anything said or discussed or disclosed in mediation is not admissible in evidence. But that is a part of the law as to whether it is going to be. So for the parties to respect that confidentiality, what we have done at the Delhi High Court Mediation Conciliation Center is to take an undertaking from the parties before commencing mediation that they will maintain confidentiality. And how do we do that? Once they log on, a window pops up where they have to say, we agree. And that the point is, in that there is an undertaking by the parties that they will maintain confidentiality. So that is very important, because confidentiality goes to the very root of mediation. Because mediation, especially from the side of the mediator also, it sort of, it builds on trust. It builds on connecting with the people. It builds on a rapport that you have with the people. So unless that trust and confidentiality is maintained, the mediation can never achieve its purpose, and it will be derailed. The entire process will be derailed. So I think confidentiality can be maintained through the ODR forum, but the parties must give an undertaking, and even the mediator must agree to those terms the moment you start your first session, that you will maintain confidentiality. The second part of the question is whether private sessions can happen. Yes. Now, unlike, for instance, Zoom, I was having I was trying to mediate parties outside the center. They wanted to conciliate really to help. So I wanted to have a separate session. Now, Zoom is a problem. How do you do that? So you have to request the party to exit, and then you send a message and then tell the party to join back. Now, it is a very cumbersome process. Now, what you do in our WebEx in the High Court is that there is a waiting room, or a lobby, we call it. So the host at the center, the IT person sitting there, we requested that, all right, now I want to speak to only one side. So therefore, shift the other side to the waiting room or the lobby. So he takes them off from the screen. So they can neither hear nor they can participate. And you're having a private session. Then when it is over, then you tell that IT person to get them back and take one side, the other side out. So that private session can also happen. And it's happening very successfully in the Delhi High Court Mediation Center. I myself am experiencing that. I think it's a very, very effective. And so in WebEx, this process is possible. Today, technology has gone really far. I mean, we're all, like Mohini said, we're all learning now. We're all coming into it and discovering all those things. And it's amazing to see how virtually we can do almost everything that we could do in the physical form. But yes, that personal touch of a mediator through electronic platform definitely is missed. And I really feel bad about it, because you're not able to sit with the parties, you're not able to connect so well and so quickly. Of course you are. It depends on how you connect with them, even through this platform. But I think the physical presence makes a lot of difference. But again, this is only a passing phase. We are not going to, we haven't sort of going to do this for the rest of our lives. There's going to be physical mediation also. So therefore those matters in which that kind of emotions or sentiments are not involved, that kind of confidentiality is not so important. Those are much more effective in ODR than the others. But of course, confidentiality can be maintained and private sessions can be conducted. Yeah.
Thank you, sir. Rubina, over to you.
Yeah. Thank you, sir. Ma'am, our next question is basically again vis-a-vis the COVID times, as we all are going through this phase of new normal. So, ma'am, what we wanted to understand was, what is the relevance of ODR in this COVID-19 situation in terms of efficiency, in terms of ease of doing business, in terms of everything? Because even our court hearings are being conducted virtually, as we all are aware of. Hence, I request you to guide us and elaborate us on the relevance of ODR in COVID-19 situation.
See, as I've mentioned before, I think in my previous answer, I've also explained a little bit about this. Yeah. And of course, these are changing times. Everybody is changing, and technologies, everybody is gearing up. uh, ourselves into this change what is happening, which is becoming now new normal. So ODR, in my opinion, in this changing times has a great significance. As you have said, that courts are also not functioning. We are also getting onto the e-filing, video conferencing. All these things are being used. The technology and the digitization is the new normal now. The technology is the new normal. Video conferencing is the new normal. So that is what is happening. And of course, the courts are also gearing up. We are also gearing up at the same time. At one point of time, Supreme Court e-filing was not there. Now it is becoming normal. Everybody is coming on and changing onto this platform now. So now, as I have already mentioned, that youngsters are comfortable with this kind of digitization, with this kind of working with the technology. So they are not alien to it. So all people like us, and of course, I feel that lawyers have to also gear up for this, because this is going to be now in the new, in the coming times. So it's going to be both video conferencing as well as physical hearing that is going to take place. So it's not going to be only physical hearing, it's going to be technology-based hearings as well. So we do need to change. So the long drawn process, as we have seen in the litigation, is, I think now with the use of technology, we are also finding ourselves comfortable and we feel that it is not preferred. So ODR, in my opinion, really is an ideal solution to these issues and has several advantages that are especially relevant in these times. So with the advent of the technology in the dispute resolution, we can envision a greater access to justice. Disability is converted into accessibility. The need for travel from one place to another is eliminated or minimized. And digital accessibility is greater for persons with disabilities now. Earlier, they probably would not be able to reach the court, but yes, now they are. It is accessible to them. Sitting at home, not moving out from anywhere, it is available to them. And they are able to directly participate in dispute resolution mechanism. So ODR is also is immensely cost effective. That's another point that I would like to make. So people located in far-flung areas are not placed at a disadvantage and are able to quickly resolve the disputes. The process is efficient, faster, minimum time is taken, as no time is lost, especially on travel and adjournments in the court of law that we see. So the process is also more sustainable. There may not be need for any paper used in ODR. So it's ecologically sustainable. Mechanism is also filing of documentations can be submitted online. You don't have to file the physical copies. It can be filed. End-to-end encryption is there. The documents can be filed. As far as confidentiality of the documents, that can also be taken care of once it is end-to-end encrypted. So there is enforceability of awards also made on settlement reach, as Sudhanshu has also mentioned in this, how the enforceability of the awards. So have greater bargaining power and in the process. So in my opinion, ODR is ideal where emphasis of the parties is on building relationship rather than ascertaining, as Sudhanshu has mentioned in the previous matter in the family disputes, is ascertaining the parties at a fault for which what has already transpired. So in my opinion, yes, building relationship, yes, where they don't want to see each other on face to face, maybe that's a barrier. Well, you are on a computer screen, the other party is also on a computer screen, but yes, you are accessible to the mediator or a conciliator where you are not in presence of each other, but still you are speaking. Especially I'm talking in the family matters, as Sudhanshu has. Of course, you have issues with regard to trust and emotional issues are there which has to be probably addressed. So the outcome of a successful mediation, for example, is a settlement agreement, is not a decision. The objective here basically is to evaluate how a matter can be resolved through the technology, through the technology and the platform available. So in my opinion, these are certain things with regard to the accessibilities, accessibility becoming disabilities, and with regard to the cost effectiveness, these are the things that probably are in terms of efficiency and ease of doing business, this will really help. Where the answers are given at a, and the disputes are resolved in a matter of fractions of time, where people are not spending more time traveling from one place to another. You're sitting in Nagpur and the other person is sitting in Chennai maybe, and a mediator probably is in Delhi. And as long as you choose a mediator and a conciliator, while sitting at your places, you can decide what is it that you want out of this dispute. So this, of course, increases greater efficiency, in my opinion. ODR is there to stay, in my opinion.
Thank you, ma'am.
Yeah.
Yes, ma'am. It seems that it will stay. It's being adopted widely in UK. Resolver are kind of companies who have been adopting this. So now we'll come to the next part of it, sir. Like now this is more relevant, I think, for the lawyers. You know, that what are the things that we need to keep in mind while drafting the clause of arbitration, mediation in the agreements? So what are the things that we must keep in mind, sir?
Udit, there are so many judgments now on seat and venue in arbitration. So keeping the present law in mind, we must look at certain aspects which must be incorporated in the arbitration agreements between the parties. Now, first of all, as far as arbitration is concerned, I'll then come to mediation. The number and qualification of the arbitrators must be clearly given. It's a sole arbitrator, or there are panel of arbitrators, or there are arbitrators appointed by either of the parties, each of the arbitrator, and then the two arbitrators appoint an umpire or the presiding arbitrator. Now, those things, the constitution of the arbitration must be clearly mentioned in the clause. In small kind of disputes where money is not so important, I mean, not so huge, then sole arbitrator may be worth it. But when there are huge amounts involved, the pecuniary value of the dispute is very high, then it will always be better to have a panel of arbitrators. Now, the qualification of the arbitrator is also important, because the kind of dispute that arises may need some specialized qualification. That's why in certain arbitrations we have two technical persons and one judicial person, one person with a judicial mind. So the qualification of the arbitrator could be as far as possible, depending on what kind of agreement it is where you're drafting the arbitration. So that also should be written. Then the procedure for appointment of arbitrator, there should be no ambiguity about what is the procedure is to be followed. For instance, if it is an ad hoc arbitrator, see also in appointing, how with mutual consent, failing which go under the Arbitration and Conciliation Act, or an institution will appoint, an institution's rules, procedural rules will apply, and so on. So all those things one must keep in mind. Again, it depends on what is the kind of contract, what are the kind of dealings that the parties are having, because that will really depend on what you choose, whether you choose an institutional arbitration or an ad hoc arbitration, and then what is the procedure of appointment that one should really adopt. Then, of course, the seat of the arbitration. One must not use these terms loosely. Sometimes you're using venue, sometimes you're using seat, and a lot of confusion is being created. So a seat of the arbitrator, one should try and avoid using the word venue. I think that really has created, there are so many judgments on this now. So a seat of the arbitration must be also incorporated in the clause. The language of the arbitration proceedings, what you need to, and also what are the governing laws of arbitration. And those aspects one should keep in mind broadly. I mean, of course, I'm just giving a very broad framework of what should be kept in mind while drafting the arbitration clause. Now, in mediation, I think one should keep in mind that there is something known as med-arb. So when you're drafting an arbitration clause in an agreement, it would be useful for the parties to first tell them to go through the process of mediation. So the parties agree at the outset when they're entering into the agreement that they will first try and resolve their disputes through mediation or conciliation. So that part must also be incorporated in the clause. And if that fails, then they can go into arbitration. So then again, who is going to be the arbitrator? Who is going to appoint the arbitrator? It can't be one-sided. Now there are judgments, even arbitrators, if it's appointed by one party, it may not be, it's now frowned upon by the courts itself. So therefore, even a mediator, it is better to sort of suggest that the mediation center, any institution that is of repute, can, the parties can approach and that person can appoint the mediator. So the qualification of the mediator also needs to be kept in mind. And it is better also to, record as to where the mediation proceedings will be held and whether they're going to be using electronic platform or they're going to be using it physical. And if there is a center, they must use it at the center and so on. So all these things you must be broadly kept in mind when you're drafting the mediation and arbitration clauses. Yeah.
Thank you, sir. Next.
Ma'am, my question will be to you, since we are talking about the agreements and the contracts. Seldom we will see, at least in India, seldom we will see that there is any clause with respect to ODR as an alternate dispute resolution mechanism like we have arbitration. So in that context, ma'am, I request you to guide us as to what strategies should we take vis-a-vis the ODR strategy in existing contracts where we do not have any such special clause of referring the dispute for for online dispute resolution method. And to add to that, madam, we also request you to help us in guiding us with respect to renegotiating such existing contracts where we can take benefit of ODR resolution.
Rubina, your question is closely related. So I will answer in a little elaborate manner. So usually in the case of a commercial or a contractual disputes, the contracts must specify the means of dispute resolution. Like even in arbitration, when there's an agreement. So if there's any dispute which falls, so what is the resolution process that should be there? So in the Arbitration and Conciliation Act 1996 requires a written agreement that specifies the method of appointment of an arbitrator. Sudhanshu has also mentioned it, also the venue of arbitration and the applicable laws, etc., etc. So as far as mediation is concerned, there is no such contractual backing is necessary, in my opinion. And the parties can voluntarily choose at any time to enter into mediation. So in case where the existing contract does not have the requisite clauses for alternative dispute resolution, they may need to be renegotiated, in my opinion. And as Sudhanshu has also mentioned with regard to Med-Arb, so as of now, all the agreements, whatever we have seen and whatever disputes have come for mediation or arbitration, there's only one clause, that is of arbitration. So in my opinion also, there should be another clause which should also be written, which should be also incorporated in the agreement, is that of mediation. So once you have what Sudhanshu was mentioning about Med-Arb, so once your agreement incorporates a mediation clause, so any dispute that can be first addressed in mediation. If it settles, well and good. If it doesn't, then it goes off for arbitration. Or it can be some part of the dispute can be settled in mediation and some part can go for arbitration. So it is necessary that for the future, parties should incorporate mediation in their agreement clauses. So especially now in this post-COVID world, there is a great necessity for renegotiating contracts. The nature of business, everything is changing. The contract must change to account basically for the commercial agreements, concessionaires agreements are there, tenant-landlord agreements, and even employment contracts may need to be reconsidered and modified. So here it has to be renegotiated. So here, in my opinion, negotiation has a crucial role to play where the parties have to come forward, sit together and renegotiate the contracts. So parties need to seek to negotiate and arrive at a workable strategies themselves. So if this does not work, they can approach a mediator. So here in this case, the mediation can be carried out online. So that's where I'm bringing in mediation. Suppose the parties themselves are not able to renegotiate the nitty-gritties of the contract. So there the help of a mediator can be used. The mediator skills can be used. So mediator here in this case will help the parties to evaluate their options and reach the best strategy to move forward. So online modes of ADR are very, very relevant in these times for renegotiating agreements, whether it is negotiation, mediation, or conciliation. If we don't provide the platform now at this stage, the disputes will end up in the courts. So it is important that it is renegotiated, access to the mediation and the conciliation, institutions can be approached for all this. So it's not that once a dispute has arisen, you go for the resolution of that dispute, but at this stage also, contracts can be renegotiated. So this is what I feel, that negotiation is something which really parties have to gear up and start off with.
Thank you. Thank you, ma'am. So now I'd like to just put a question to Sudhanshu, sir. This is again in continuation to your previous question, sir. As you said that the courts have frowned upon the parties individually selecting the arbitrator, appointing the arbitrator, right, sir? So it's with respect to that, I want to know that in appointment of mediators, I mean, what is the process followed in the appointment of mediators, conciliators, as well as the arbitrators? Sir, you're mute, sir.
Sir, you're mute.
I'm sorry. I had muted when Mohini was talking, so I'd forgotten. See, it's not a question of the process. Of course, when you're choosing a mediator, conciliator, and arbitrator at the beginning of the agreement, you have to bear in mind just a few things. One is that you must have faith in the person. See, it's neutrality, impartiality of the person that carries that process. It's neutrality and impartiality. So you must have faith in the person. That person must have sufficient knowledge, sufficient experience, and both parties must trust that person of carrying them through these conflicts and helping them resolve their issues. Now, this I'm talking about non-adjudicatory system. Now, even for arbitrators, the person has to be completely neutral, but the person must have also competency to adjudicate. So therefore, the knowledge of law is required, to my mind, both by mediators, conciliators, and by arbitrators. But arbitrators' knowledge of law has to be much more sufficient, because after all, that person is going to decide the issue in accordance with law. But a mediator and conciliator must have sufficient knowledge to be able to guide the parties through the right path. You see, so therefore you must have in mind that what is the qualification, who's the person, and I can tell you, market forces ultimately decide who is a worthy arbitrator, who is a worthy mediator, and who's a worthy conciliator. So you must have those things in mind while drafting the agreement, that the parties both have reposed faith in one person. Now, if the earlier now law that the department will appoint their own person, that is now no longer valid in view of the latest Perkins judgment, I think, of the Supreme Court. So you have to look at somebody who's outside both of them, who has no direct or indirect interest in the parties, who's completely independent. So Therefore, the best thing to do is, and if you're not sure, if you're not aware of who that individual is, you don't adopt the ad hoc method. You adopt the institutional method and leave it to the institution, because the institution, in order to create its reputation, in order to maintain its reputation, will have only those people on the panel who are, well, I wouldn't say accredited, because there are no accredited mediators or conciliators. There are certain accredited arbitrators by certain institutions, but they will only impanel those people who are competent, who have the integrity, who can be trusted, and who can carry the parties through the entire process, and not also sort of abandon them midway. So you must choose the mediator very carefully, or the arbitrator. And if you are sort of in a position where you cannot pinpoint on some individual, you must approach an institution to help you do that.
Thank you, sir. So I think my next question was...
Yeah, we are actually running out of time. I mean, we've crossed 6:15. It's supposed to be till 6, but doesn't matter. I think we should.
But I think our participants have stuck around, sir. They're increased and they're sticking around. So
okay. I'm glad. Yes, sir.
The
unfortunate part is that you can't see them. So
just to add on Udit's thing, we have already received number of queries, sir.
Oh my God.
I'm sure we will not be able to address right now.
No, but we can. We surely will. I mean, I know there's paucity of time, but in case you people want, we can, you can write those set of questions, and during our spare time, we'd like to address. It's important that the public is made aware of how effective and important this resolution dispute forum is. It's not going to be a substitute, but yes, ultimately, this forum will assist the parties in actually going back in a win-win situation and be in a much, much more happier situation, because the conflicts that really eat up the parties affect so much their health, their finances, their time. There are so many issues that come in their way. And therefore, this forum, I think, an alternate dispute resolution forum, is the most appropriate for the parties to encourage them to participate in it. Please carry on.
Sure, sir. So what we'll do is we'll consolidate all the questions and share it with you and ma'am. And then that's how we can take it.
Sure.
So my next question was very related to the previous one itself, and you answered fairly a part of it. Is our ad hoc mechanism better than institutional ADR mechanism, sir? So you've answered on the appointment part. For the rest, sir, I would like
yes,
to...
I think it depends, Udit. I would not make any general opinion on it, because as I said, when there are disputes that don't involve so much of money, then institutional arbitration may be more expensive. But otherwise, institutional arbitration for large disputes where huge amounts are involved, it would be better, because there the expenses are more. The administrative arrangements are made by the institution. The ad hoc arbitrator doesn't need to bother about it. The parties don't need to bother about arranging the place, arranging all those things. So there are a lot of advantages of institutional arbitration, many more over ad hoc arbitration in disputes that are of larger magnitude, where huge amounts are involved. And also that there is more scope for you to choose your arbitrator from the number of arbitrators who are on the panel of their institution. So that advantage also you get. And also there is some supervisory body which is sitting there and managing your administrative affairs, which make it very, very convenient. So, I mean, I would really say that ad hoc arbitrations or ad hoc mediations are very effective, are good. You choose the mediator or the conciliator or the arbitrator that you have confidence in, that the parties have confidence in. But in not very, very large disputes, unless the parties are sufficiently equipped to arrange that kind of administrative setup for the parties. But it is always better to go for institutional arbitration. This is my view.
Thank you, sir. Ma'am, my next question is again with respect to ODR, and it's more of a practical or realistic question, because ma'am, there is a scenario, like for example, that a dispute was referred on ODR platform and it was settled. Settlement agreement was entered into between the parties. However, if there is a default on settlement terms by any of the parties, then how can we ensure enforceability of this settlement agreement, ma'am, is the query that is.
I'll answer this question. I'm taking a scenario where it is a pre-litigation mediation. It is not a court-referred mediation,
Yes.
and it's an ODR platform. It's a pre-litigation mediation. So here the settlement has been arrived through ODR methods, and they are enforceable, quite easily enforceable as the other way, the settlements are arrived at in the physical form of mediation. It's a little different here, difference in the terms of use of technology. That's how you do it here. So here, what happens is that in ODR, firstly, so here it comes to the process. So it's before you start the mediation, everything, there's a pre-agreements which have to be signed by the parties that they are coming in for mediation on the ODR platform, on the online platform. So here the parties would be required to sign all agreements involving, which will include the confidentiality agreements. So confidentiality, Sudhanshu has already spoken about with regard to the ODR and how it can be. So the parties have to, before they start off with the mediation, they have to sign certain confidentiality agreements. There can be a pre-agreement in place between the parties, which is duly executed by both the parties. So the pre-agreement would lay down the rules on documentation and the process for ODR. Accordingly, the ODR process is carried out and the settlement is arrived at. Now I'm coming where the process is carried out, rules are devised, rules are there, parties have signed the pre-agreement, settlement, process of mediation has started, and the settlement is arrived at. So the terms of the settlement are captured in another agreement, which both parties will execute. All signatures can be digital, has to be signed, even the mediators' signatures have to be digital. So all these digital signatures are valid under the IT Act, and the settlement agreements becomes enforceable. So as what you are saying is that what happens when the agreement is signed and the one party retracts from the, that's what your question is, right? When the retracts from the agreement. So I'm taking two positions here with regard to where both the parties have signed and where one party has retracted from the agreement. Where both the parties have signed the agreement, it becomes enforceable. How it becomes enforceable? We are dealing with pre-litigation mediation. So Section 73 of the Arbitration and Conciliation Act provides for drawing up and signing of the written settlement agreement. So here Section 73 of the Arbitration and Conciliation Act 1996 comes into force. So Part 3 of that provides for the enforceability of the agreement. It becomes the conciliated award, except that it is on a platform. It's on an online platform. The settlement agreement must also be, as I've said, that has to be signed. When the parties sign the settlement agreement, it shall be final and binding on all the parties claiming under them respectively. So where one party doesn't sign, so like when in the other cases where one party retracts from the enforcement, when one party retracts from the execution, one has to go in for execution. So as simple as that, one has to go for execution if one party retracts from the agreement. So that is as far as the second case is concerned. So it becomes binding. So once it is a conciliated agreement signed by the parties on the Arbitration and Conciliation Act 1996, it becomes enforceable. Except that it is signed, it is digitally signed, and it is enforced in that manner. So now in case of mediation, the mediator authenticates the settlement agreement and furnishes a copy of the same to both the parties. So it becomes enforceable. So in case of a settlement which is arrived at in a court annexed mediation or a judicial settlement, the same should be reduced into writing and presented before the court for it to pass a decree on that basis. So Here, this is what the difference is with regard to an online platform, how the matters, how the enforceability. If anything, Sudhanshu may want to add, probably he can add here.
No, that's fine. I think we're running out of time, so we shouldn't be at 6:30 already. Doesn't matter. I think it's fine. Udit, you can shoot another one.
Oh, sure. So this is the last one to you then, mine. Can we force the other party, the opposite party, into the alternate dispute resolution if there are such clauses in the agreement? And so another thing to add is if there are no clauses, then also can we force the party, is what we would like to know.
I'll tell you, Udit, if there is even AFCON's judgment of the Supreme Court says that the court can tell the parties to go, whether they want to go or not. I mean, but the point is that this is a voluntary process. Unless the parties themselves want to go and use this platform, nobody can force them. Now, the only thing is in arbitration, it's straight away yes or no. You don't want to go, you can't force them. In mediation, when the parties do come by reference from court, the mediator is skilled to talk to the parties and start changing their mindset to accept this forum, as this is a more better and appropriate forum for them to resolve their disputes. We have experienced that people do change their minds because they are not fully aware of what this process is. Because there is lack of awareness about mediation and conciliation in the public, they will immediately, they feel that they've paid the lawyer, they've paid the court fees. Why should you go to another forum? Let the court decide. But the point is, what happens in mediation and conciliation cannot happen in court. Because there are those issues that are addressed there that cannot be addressed. So the parties need to be made to understand this. Once they're able to understand this, and that is the skill of the mediator or the conciliator, once they're able to understand it, the parties will volunteer to participate. So as far as voluntariness is concerned, that is extremely important for an ADR mechanism to kick in. But if there is no voluntariness, still, despite having spoken to them, despite having told them the benefits of mediation conciliation, they do not opt for it, you cannot force the parties. It is their dispute. The solution is also theirs. Therefore, it is ultimately they who have to take the call.
Thank you, sir. Over to you, Rubina. I think, ma'am, I can't hear Rubina. So maybe I'll take this and
Am I audible now?
Yes.
Yeah. So thank you, sir. Thank you, Udit. And was just saying that this is the last question of this program today, which is, ma'am, to you. So, ma'am, and there were a series of questions which has been received from our viewers as well, wherein everybody wants to know that is it mandatorily required that all settlements via mediation has to be sanctioned by the court? And just to add to that question, if the answer is negative, then how should we ensure, or what will be the validity of such settlement agreements which are not sanctioned by the court?
So here, it's almost similar to my previous question, so I will answer it once again. So here we are talking about pre-litigation mediation and we are talking about court-annexed mediation. So under the Arbitration and Conciliation Act, parties can enter into a mediation by themselves and need not be mandated by a court to do so. So if parties decide that we want this matter to be settled through a mediation, as you can either go to a mediator of your choice or to an institution, and an institution will appoint a mediator, and that mediator will be there for you for the resolution of your dispute. So pre-litigation mediation, as provided under Arbitration and Conciliation Act Part 3, answers these questions in this. So the settlement agreement becomes binding upon the parties when they execute the same and the mediator has authenticated. Then it becomes a conciliated award, which is binding on the parties. So it cannot be once it is a binding award, nobody can challenge it. It becomes like an arbitrator's award, which has been passed by under the Arbitration and Conciliation Act. So it is enforceable as an award. So as far as court annexed mediation is concerned, so here it is provided under section 89 of the Civil Procedure Code. And in this case, the settlement arrived at through such mediation must be court sanctioned. So that is what, once the settlement is arrived at, the settlement is drawn up, signed by the parties, signed by the mediators, then it is placed before the court. So then the court passes a decree on the basis of the settlement arrived at. So it becomes authenticated by the court. As far as, so this is the difference between pre-litigation and court-annexed mediation. Court-annexed mediation has to be sanctioned by the court, whereas pre-litigation becomes a conciliated award. So now there are various legislations that provide for mediation. So like Commercial Courts Act is there, MSMEs are there, and which are basically all court-annexed mediation. So they are attached to the mediation center next to the courts and to the respective high courts or to the law courts. So, however, in many cases, such legislation is not effectively used. So like, I'll give an example with regard to MSMEs cases. So I have certain figures with me. Under MSMEs Act, there are about 43,575 cases are filed every year. The money at stake is about 1,200 crores, almost 1,200 crores. And only 10% of these cases have been resolved in the last 7 to 8 years, involving just about 5% of the amount involved. So, in my opinion, there are certain legislation which probably have not been able to answer the needs of mediation, though it is provided in the legislation. But here, keeping this in mind, I feel that mediation is very effective means of dispute resolution in such cases, and the courts must utilize legislation that allows them to refer such matters for mediation. So hence, courts should, in matters, some commercial matters, commercial disputes, IPR disputes, the courts, I think, should refer more matters. In Samadhan, as far as recently I've got to know about, only 600 matters have been referred. So recently, 600 matters are pending. And whereas we have so many mediators. So I think courts needs now probably to start giving more matters to the mediation center so that they can be resolved. And as far as institutions are concerned, pre-litigation mediation should be encouraged so that commercial matters or any other form of matters can be resolved. So pre-litigation mediation, though we don't have a standalone legislation on mediation, but Arbitration and Conciliation Act answers that, fills that gap till the time we have a standalone legislation on mediation. So this is what I can.
Thank you so much, ma'am. Thank you so much.
You're welcome.
Thank you, sir.
Over to you.
Yes, thank you. Thank you, Sudhanshu sir, and thank you, Mohini ma'am, for such a great session. It was really an honor to have received such a holistic view of the alternative dispute resolution mechanism that is available and the online dispute mechanism that is developing. So sir had said that, in Zoom, there are some complications. So there are other platforms which are available, which can be used by the parties. So it's quite an enlightening session, sir, for it. And I really thank you, sir, sincerely. Udit Kishan and Associates and Fortis India Laws, sincerely thank you and ma'am and all the viewers for taking out time on a Sunday evening and, enlightening us on all these aspects, sir. We wish to have more of these, sir, and now with the industry people more involved. So we will have this uploaded on YouTube and all the questions will be mailed to sir and ma'am for all the queries. So all the participants can get their answers. We'll mail it personally to all, sir.
Thank you. Thank you very much.
Thank you very much. Thank you very much, Rubina.
Thank you, ma'am. Thank you, sir. Thank you so much.
Thank you.
And ma'am, your sari is looking really beautiful. It takes an effort to sit at home and...
That is webinar dressing.
Yes.
That is also new term.
Okay, bye-bye.
Thank you.
Bye, sir. Bye, ma'am. Thank
Bye.
you.
Bye.
Thank you all.